credit our southern Sandwich. I think historically southern Sandwich and the lands around there, Farmersville is an important area for farming, and I think is often overlooked when it comes to the history of the town. So not only do I think ecologically this is important, but when it comes to our heritage and the story of Sandwich, I think the Hog Ponds is a place I've always been intrigued by, and I am happy that the Van Buskirk family is moving in this direction. So I would applaud them and encourage other families who have similarly ecologically important land that they hold in their domain to consider such proposals. So thank you.
Well said. Agreed. Make a motion, Chairman?
I would like to make a motion to approve the conservation, Hog Pond conservation restriction proposal as written in the letter.
Second.
All right, approved.
All in favor?
All in favor?
Aye.
Thank you, Mr. Chair. And if you would perhaps an email to the Select Board for their meeting tomorrow night, that would be appreciated. Thank you.
Thank you.
Thank you.
Thank you. All right, we will go to new filings. I'd like to open up DEP file number SE66-2031, Elizabeth Nielsen, care of Environmental Consulting and Restoration, LLC, which has filed a notice of intent for a demo rebuild of a single-family dwelling at 90 Wing Boulevard East, East Sandwich, Mass., located at map 64-parcel 116.
Good evening, members of the Commission. I'm Brad Holmes with the ECR. Made a little cheat sheet that might be easier to
Wonderful, thank you.
trying to hold something.
For sure. Thank you. Thank you.
Thank you.
What I've done is just taken the existing conditions plan as a snapshot and the proposed conditions plan, so you can have it in your hand as we move along. We submitted a notice of intent for a single-family home reconstruction project at 90 Wing Boulevard East for Elizabeth Nielsen. The property contains a bordering vegetated wetland in the southeast corner of the property. It's a residential lot with a home, porch deck, a yard area, shed, and utilities come off the street. What we're proposing to do, flip onto your next page and I'll move this sheet over, is improve the property with a new home, but we'll be keeping the portion of the home and deck that's closest to the wetland and then moving further away from it. So you can see I've outlined that in the red area. That is to be reconstructed with a new foundation. As I said, these structures will remain tied to the new home. There'll be some grading associated with the new home construction. The deck here, all work occurs within the footprint of the existing building. There is a slight increase of 107 square feet beyond what is here now. You can see that we're located beyond the 50-foot buffer zone, partially within the 100-foot buffer zone. I think the project that the Commission will be a little bit most concerned with is we're proposing a new well closer into the buffer zone, about 32 feet away from the edge of the BBW. The reason for the relocation of the well is that we're putting a new Title V septic system up here in the front of the lot. And we have to have that separation, as you know, from nearby septic systems, and the proposed septic system to be 100 feet away. That well is located with an existing lawn. In order to connect that to the house, there's a proposed water line. That water line will go through this brush area here, which is partially within the 50-foot buffer zone. So we have prepared a restoration proposal to mitigate that work and revegetate it with native plantings. After the water line is installed, we'll put native plantings in a seed mix, revegetate that area so that it will be restored. It's just enough to get the water line through. The installation truck can come through the yard here, so it's not that we need to get equipment through here. The large equipment, just the ditching for the water line. Once we get the project completed, it will be restored as it is a single-family residence, stabilize it, and continue on. So I'll bring that back to you.
Anything to add?
I know you had submitted additional plans after the comment correspondence we had that came in yesterday,
Correct.
which is after the deadline. So, I mean, I did get a chance to glance through them. It seemed that you had addressed all of the comments and concerns that I had listed on there. I sent him the same list that I showed them. So, like I said, I haven't had a ton of time to stare at that and review everything. But as long as those are addressed, then that's the only comment I had.
I think they were somewhat minor in nature.
Yeah, there wasn't
to
anything
dry
crazy.
wells and some of the detail on the erosion control.
Yep.
Can go over those if you'd like, but they have been incorporated into the plan, and yes, so you didn't get them a week ahead of time. So if there's additional time needed for that, then happy to do that. But if we can dock it out here, we can do that too.
Yeah, I'm fine with whatever you guys are fine with working with if you had time to look through that. So,
I'd like to open it up for public comment at this time. And closing for public comment, opening it up to the board for questions. Comments?
To me, it seems like a reasonable application. There's a little bit of overage from what they're doing. They're giving, my only thing is that they're restoring where the water line is going. There's no other mitigation, but besides what they have removed to put back. But I think it's a strong application. It's fairly reasonable. I don't see any.
2 to 1? I'm just curious.
There is not necessary. I wouldn't even consider it 2 to 1 because really they're taking out vegetation to put vegetation back in. So really there is, if you're looking at it technically, there is no mitigation for the overage of the coverage.
Right, because we're outside the 50-foot.
That's what you prefer.
But we can always add a few more shrubs. It's not something that we'd be opposed to, but I don't think we triggered a threshold.
Right. It's always nice, though.
Do we have the limit of work on here?
Yes, the erosion control line is shown here. in the brown.
Okay, great. Wonderful.
What are you using?
Trenched in silt fence.
Thank you.
Do you have a lot of digging that you're doing for the foundation, or since you have something there, are you?
Really just demolishing the structure that's there, digging out the foundation and
Putting back in.
putting a new foundation. Generally, I mean, there'll be some earthwork to realign the new, foundation, but generally within the same area.
I think we would definitely want to see you, any of the disturbed lawn area, or any lawn area that's disturbed from your construction, we'd want to see it back with the native fescue mix.
No problem.
And, ideally moving to an organic fertilizing, if any, for your maintenance of your lawn.
We would anticipate that as a special condition, and that's not an issue.
Okay.
What about, the gravel driveway is going to be 3/4 inch round wash stone, yeah?
We haven't had I don't think we have a detail on that, but whatever you guys normally look for.
Yeah.
Sure.
Yeah, could we put that in there?
Sure.
Rather than
I
gravel?
mean, it's outside the buffer zone,
Oh, it is.
but we just call it out as gravel, so,
It's like a nice little, bonus.
sure, okay.
Okay. Maybe other than that, I'm good.
Other than that, we're
Yeah,
good.
Okay.
All right.
Someone like to make a motion?
Yes, we're here, right? 90 Wing. I'd like to make a motion to close and approve DEP file number SC 66-2031 Elizabeth Nielsen, care of Environmental Consulting and Restoration LLC, for the notice of intent to demo, rebuild a single-family dwelling at 90 Wing Boulevard, East Sandwich, or Wing Boulevard East, East Sandwich, Mass., located at map 64, parcel 116, with special and standard conditions as discussed.
I'll second that.
All right, all in favor?
Aye.
All right, approved.
Thank you very much.
Thank you.
Thank you.
Everybody get to set off on a good motion here.
Good job.
That's right. Good job, Brad.
All right, next. Next, I'd like to open up DEP file number SE66-2032, Emmett O. Raftery, care of Down Cape Engineering, Inc., which has filed a notice of intent for a demo rebuild of a single-family home at 365 Phillips Road, Sandwich, Mass., located at at map 95, parcel 49.
Good evening, Chair, members of the Commission. Dan Ojala, I'm a land surveyor and also a civil engineer with Down Cape Engineering in Yarmouthport. With me is Rick Anderson, who's a co-applicant with the owner and builder of the property. This is at the very, very end of Phillips Road. It actually backs up to the state park there. So there's no neighbors to the east, just some vacant land. There's town land to the north, and this is a pretty straightforward raise and replace. This area, we had independent environmental assess the resource areas. You're looking at way to the north, the Cape Cod Bay coastal beach, transition into a coastal dune, which wraps pretty much around the property. It's also in the velocity zone, which is a VE elevation 16. The house was constructed in 1967. At that time, the water was about 200 or less than 200 feet from the building. Now it's almost 500 feet from the building. This is accreting on the north side due to the large jetty. I think it's pretty much acknowledged by the Army that jetty is causing some accretion on this side and perhaps a little depletion on the other side. But we're the beneficiaries of that, so it's not particularly close to the water. There's a nice little path, natural type path down to the water through the town property. And again, it's been here a long time. What we're looking at doing is not increasing the number of bedrooms. We're going to exist in Title V septic tank and leaching. We're going to leave that alone and simply elevate the building up on piles. We're retreating a little bit. On the water side, there's a pretty extensive deck system. We're pulling that back, increasing the footprint a tiny bit, but getting rid of all the paved driveway and replacing it with pervious gravel. We figure we'll pull in and park underneath the building. There's a pretty extensive set of stairs to get up on top. To mitigate against a disturbance where all the deck was, we're replanting with American beach grass. We would be introducing a little dry well there just in case or to improve the drainage situation. But you can see we're on the order of about 1,100 square foot of revegetation when we're disturbing on the order of 800 and some square foot of area that's only lightly disturbed right now. So we think in the net it's a great improvement. Our analysis goes through the standards under state and local regulations. I'm sure you've looked at that, but I think being up on open piles will allow the dune system to move through, allow if there ever is a huge nor'easter, waves to move through unimpeded rather than damaging the building and causing debris in the area. So we think it's a good project. Be glad to answer any questions if you have them.
Anything to add?
A little bit. So I know we had discussed the original comments that you gave us new plans that addressed those original comments that I had.
Yes.
The other thing on that original list was the gravel driveway. We can't do gravel in a dune. It's going to be 3/4 inch washed native stone. So just changing that. And then
Perfectly acceptable.
awesome. And then we talked about the coastal dune delineation with boring samples to support that data. Just because there's concern about the line being where the dune is, or if it encompasses the whole property. So.
Yeah, fair point. And I was unable to reach out to Paul Shea in time for the meeting. We did try, but I'd been away, and I guess he's been away. But the thought on it is basically there's an existing home there that's been there since 1960, a paved driveway. Generally, we wouldn't call that a coastal dune under those surfaces.
Okay.
The delineation, you kind of just check on the Mass GIS, basically goes in the general area that we have it mapped. Perhaps if we could have it approved contingent upon Paul getting you a couple of corings to prove that out. I think if it were all coastal dune, would still meet the standards. but I think it's pretty straightforward to argue just a little bit isn't. Again, we'll still fully meet the performance standards because we're up on open piles, lowest horizontal structural members way above grade, nice and safe, high and dry. So if we could move forward under those conditions, we'd appreciate it. If not, we could certainly continue.
Yep, I think that's understandable.
Okay. I'd like to open it up to public comment. And we'll close public comment, open it up to the board for questions.
Dan, do you know the age of that septic system?
It is, it looks like it's post-78, so I don't think it's an OEM. I think it's newer than that. We did have a fresh inspection, and it passed with flying colors. It hasn't been used heavily over the years.
Is it
So.
a field?
Yeah, well, it's a trench-style system, so here it
Trench.
is here. It's a nice, long trench, 3-bedroom, and the tank is right in that area there.
Okay.
So it functions fairly well, and we're about 15 feet above sea level at this area.
There was one question, I think, that we had about the amount of mitigation. It's somewhere shown as plus or minus 907 on your plan, and then, or on your top, like, chart, and on your plan, it's like 1,001 or something.
Yeah, I think we didn't add in that little area there.
Okay.
When you add them up, it's a little bit more. This is about the 880, and then we tacked a little bit more on there, so the 1,100 would be accurate.
I think it seems reasonable, the planting, the replanting.
When it comes to the removal of that cement foundation, what kind of steps do you partake in that ensures that the site isn't further degraded with all of that activity?
So, we've got a building to remove and a foundation. Rick has been building for probably 40-something years. What we'll do is get a licensed contractor to demolish it, bring it to a licensed reclamation facility, waste handling. The concrete, you basically grab it and pull it up rather than, you can't bury it or anything like that. And we've got, timber piles to drive, so we can't deal with deleterious materials underneath the footing. So they'd all be carefully plucked, stacked, and loaded onto a truck and removed.
So when it comes to the site itself, it looks kind of like the land around it is up higher. So if you're removing this cement foundation and putting pilings in where it is, what kinds of issues might there be? Especially, it looks like we have a sloping site here with erosion underneath that existing site. It just seems like it will be a more difficult terrain, perhaps, when it comes to, despite the fact that the dune is going to be moving, if it might be worsened. So I don't know if you build up the site underneath where those pilings are going.
So I think the way we'd handle it, we really only need to park right where the house is now in this level area. There's a little bit of a, kind of a mound, a couple foot high over here. We'll leave that be. We're so much high above it, we'll simply drive through it, and if that decides to migrate south a little bit, so be it. I think we'll just let that natural grades fall off. Sand will fall off at a 1.5 to 1 slope and be carved by the wind. But we're simply interested in maintaining a level area just under the footprint. So to the extent that there's a little bit of topography, I think we'll just let it be and let it migrate as needed.
So I guess maybe just since we're going to have migration, having more plantings there, because we know, which seems like the migration's good, but if it also takes down some of that beach grass.
Well, we can maintain the beach grass. We'd be happy with a condition about that. It's pretty hardy. Well, you don't step on it.
Yeah.
Are you talking about under the building?
If this is going to be
like this
shifting, yeah.
Should be 2 to 1.
So you're taking out a traditional is there a basement and crawl space or something?
Yeah,
And then you're
basically a big crawl
infilling
space.
it with what kind of material?
So it's basically a sandy matrix that's out there now. Would introduce just some native wash stone, get rid of all the pavement, but simply level out the ground underneath it. It's a material that we feel we can pull in and park on right now. Wouldn't look to do pavers or anything like that under the building. Just leave it be at like the natural wash stone surface. And then the extent that there's some sand under here, we're just going to leave it.
So
That was
wash
the plan.
stone underneath the building?
A
is what
little
you're
bit,
thinking?
we're under the footprint, yeah, to level it off,
Okay.
make sure that it drains well, nothing that's not native.
Yeah, that's what we wanted to say, sand or wash stone.
Native wash stone would be fine. 3/4 inch.
Anything else?
And the driveway too is not gonna be gravel, it's gonna be 3/4 inch, right?
Yeah, gravel's kind of a loose term, but we'll correct that and put on the correct term, 3/4 inch native wash stone.
So that needs to be on the site plan before. we-
Absolutely, we'll put it right on there.
Because we're not gonna put it contingent upon, right?
Nope, happy to do it, and we'll have it within a week for sure.
Downspouts and leaching trenches, all that's gonna be identified.
Yes.
So we know where the stormwater, okay.
Yeah, we've got a detail on that.
So we can continue then.
I can do it.
Do you guys have anything else to add? What?
Need to project towards the mic.
Oh, sorry, okay, I'll just bring it closer. Thank you.
There we go.
I know, I haven't heard anything. Okay. I usually get scolded.
I'll motion to continue file number, wait, are you be ready for the next meeting?
It's up to you if you want to approve it contingent upon receipt of the plan or do a continuance, whatever you'd like, but yeah, next meeting, no problem.
The 20th.
20th.
When's the next meeting?
So motion to continue file number SE 66-2032, Emmett O'Rafferty, care of Down Cape Engineering, Inc. Notice of intent for a demo/rebuild of a single-family home at 365 Phillips Road, Sandwich, Mass., located at map 95, parcel 49, continued to November the 20th.
All in favor?
Aye.
Thank you very much for your time.
Thank you.
Thank you, Dan.
Thank you. All right, I'd like to open up DEP file number SE 66-2033. Peter Wild, care of Stantec Consulting Services, Inc., which has filed a notice of intent to relocate existing stockade fence, removal of trees, and removal and upland relocation of approximately 94 cubic yards of wood chips subject to land court ruling on proposed easement relocation at 46 and 64 Roos Road, Sandwich, Mass., located at map 69, parcels 25 and 24.
Thank you, Jeff. You read my mind.
Yes. Thanks.
Hi there.
Good evening. My name is Peter Viteri. I'm an attorney with the law firm of Barrow Dana in Boston. I'm going to give a brief background on some legal background on this case and explain sort of the reason we're here tonight. And I'll pass it over to Michelle Stevenow from Stantec, who's going to go over the technical details of the project. So essentially, this is a project that deals with parcel property up between North Shore Boulevard and Roos Road. It deals with a subdivision that was created on a land court plan in 1958. The land court plan shows a right-of-way essentially going from North Shore Boulevard to Roos Road, and there was only 14 or so of these houses that exist now today of the subdivision actually got sold and built. The road, that's North Shore Boulevard extension today, only got built to the last house. Everything after that towards Roos Road is paper street and paper lot. Completely undeveloped, and it's part of the parcel that's now owned by Mr. Wild for Idlewild Acres. In 2014, Mr. Wild made a petition to the land court to sort of clear those paper streets. A group of neighbors countersued, claiming that they had rights of way over the easement. That case went to trial in the land court. The neighbors prevailed, and the land court declared that the neighbors have a right for pedestrian and vehicular access all the way from North Shore Boulevard over this right-of-way to Roos Road. So, and then the land court also said that Mr. Wild had to remove any obstructions that he had placed within the 50-foot layout of the right-of-way. So, what that ended up being is a stockade fence that's outlined in green here that sort of goes to the last house on the lot. There's tree plantings that Mr. Wild placed there. There's sort of a wood chip raised mound grade along the fence line and where the trees were planted. That's a few feet above grade. And then there's a pond that was, that's kind of the existing right-of-way goes through right the middle of the pond. So this project addresses those first three things: the fence, relocation, removal of the wood chips, relocation of the tree plantings. It doesn't address the pond work, and the reason for that is in discussion with Mr. Wilder, we made a determination that it was unlikely that he would be able to get approval from the commission to fill that pond, or from the EPA, who has a consent decree and a conservation restriction on this property as well. So, and I had discussed that with Mr. Wrigley, the former conservation agent, about a year ago. I met with him on the property and discussed this project with him, and he concurred that it was unlikely to get approval to fill this pond. So the solution to that, or the proposed solution from Mr. Wild, is to move the easement to a different part of the sort of where it connects with Roos Road. So instead of coming all the way down here and connecting with Roos Road down here, the plan is to relocate the easement this way and meet Roos Road there. So there's an area of work here, and the way you relocate an easement in Massachusetts is you have to file a new lawsuit. So we have a pending lawsuit that we filed with the land court in July. That's just for moving that easement. That's still going on. So the work that's proposed in the area where that new easement would be, Mr. Wild he wants to get that approved and in an order of conditions, so he has that good for 3 years and able to do it, but he's not going to actually perform that work until he's got all the approvals from the court or anything like that, and he's willing to stipulate to a special condition that provides as such. So that's the legal background. I'll pass it off to Michelle to go over the technical aspects.
Good evening, everyone. Michelle Simino from Stantec Consulting. So Attorney Viteri covered the background, and now I want to just kind of dive into the resource areas on site and get you oriented to what's where, and then the more specific proposed work. So we've zoomed in here on the northern section of the property, and my colleague and I delineated the resource areas in the vicinity of the project. We've got an isolated vegetated wetland here, about 2,560 square feet of isolated vegetated wetland. We've got a pond here that has kind of a narrow fringe of bordering vegetated wetland around it. We've got some wetlands over here that were part of the previous consent decree, so we didn't delineate those as part of this effort for this project. And then the whole lot is located within land subject to coastal storm flowage. It's a FEMA Zone AE at elevation 14. So effectively, the entire lot is within land subject to coastal storm flowage, which of course is a resource area unto itself. What I've done here is the actual wetland resource areas are highlighted in the pink. The 50-foot buffer zones under your local bylaw are the yellow, just to kind of draw your eye to everything. And then in orange is the 100-foot buffer zones. And we obviously have overlapping buffer zones all over the place, but just wanted to get you oriented to the site. And then, as Attorney Viteri mentioned, there's the existing stockade fence along here. Actually, a little bit more to the plan here. It extends down here to North Shore Boulevard. And then to draw your attention to an existing chain link fence that goes through the middle of the isolated vegetated wetland. To show you what's being proposed, Attorney Viteri mentioned all of the basic components of the work here. So just to go through them here, we have so he was mentioning the relocated easement. So I just want to draw your eye to, this is the existing easement that goes through the ponds. The proposed relocated easement takes off here from North Shore Boulevard and goes this way, kind of squeezing between the two 50-foot buffer zones and not going through the pond. So to affect that change to the easement, the proposal is to remove some existing wood chips over on this side of near the North Shore Boulevard to remove up to 130 trees. And I say remove because they're not all going to be cut. They're going to the extent possible, be relocated on Mr. Wild's property, wherever he can reuse the trees and save them. They were nursery stock, and that is part of the agreement of the order to move those trees because they are obstructions that he planted. Just to clarify, he's not removing anything, the native trees that were already there. He's only removing what he planted. And highlighted, they're very, sorry. You don't have to evacuate. That's right. Okay. And so then I highlighted in this area, there's specific trees, the high spruce, the high juniper. We had the PLS who did the property boundary survey the trees, so we've got DBH on all of them and an inventory of what's being removed. The pink section is, again, within this boundary, some larger poplars and high junipers. Then the existing chain link fence will be removed. And really the most significant thing to adjust for this easement is to take this existing stockade fence and move it here to the edge of the 50-foot easement. Just relocate that, basically pick it up in kind, just relocate it. And then the second part of that is to provide a boundary in the lower portion of the easement. And so Mr. Wild is going to extend that stockade fence. The stockade fence will have footings, and the footings will be roughly 3.6 square feet of kind of surface area coverage as they establish the footings. And then the stockade fence will have, we're proposing a 1-foot clearance at the bottom to allow for, it's inland subject to coastal storm flowage, and also to allow for wildlife movement. And that's consistent with what is there now. I think in the beginning I mentioned the removal of the wood chips within the easement. So just to point out, now that you're a little bit more familiar with the property, here, and then any wood chips that were used to establish the nursery stock along the existing easement.
Great, thank you.
Thank you.
Any comments you would like to add?
I did have some initial comments that you had responded to. I think your responses were fine. They were adequate. I think you guys had time to review those, and if you agree with their responses, unless you have any other issues with those, I think I'm all set.
Okay.
I think that was all answered pretty well. So
I'd like to open up to public comment.
Perfect. Do you want to come up
Would
to the
you,
mic,
please
state
come
your
up,
name?
State your name and address, please.
Good evening, members of the board. My name is Bill Henchy. I'm an attorney from Orleans, Massachusetts. I represent, represent all the neighbors on North Shore Boulevard Extension. I represented a 10 citizens group that appealed the DEP's superseding determination of applicability that overruled the commission.
Sorry, you're not done.
And I also represented these folks in the land court and obtained the judgment, which has resulted in Mr. Vitteri's client coming here again. As an initial matter, I'm very surprised that the applicant here didn't consult with me or my clients with respect to the filing of this notice of intent. In very material respects, it violates the land court's judgment and orders, and I'll go through that in a minute. In particular, I find the notion that there's a notice of intent to relocate an easement to provide for pedestrian access only, when the order of the land court was that my clients had the right to use these ways for all purposes for which public ways are used in the town of Sandwich, frankly, to be in bad faith. So what I'd like to do with the chair's permission, it's going to take a few minutes because there's a little bit of history here, and I recognize that there are a lot of new faces since when I started with this case in 2018, when it first came on across my desk. So going back to Peter, I'm going to have to send you copies of what I'm filing because I don't have spares. I'd like to start with
Yes.
some before and afters prepared by Stantec for the DEP adjudicatory proceeding, Mr. Chairman. I've got copies for each of the members of the board. I'd like these to be made part of the record. I'll send copies over to you guys.
I'll make notes.
To orient the commission, first of all, let me say this. Everything that you see on this site, is unpermitted under the Wetlands Bylaw in Sandwich, is in violation of the Wetlands Act, is in violation of multiple enforcement orders issued by this commission, which have been appealed and which have not been decided by a court. This plan violates a judgment of the land court, and I'll start there and let me go through this in some particularity. So with regard to what I just handed out, Peter, I got a copy for you. Here. The first page, and these were all prepared by Stantec as part of an adjudicatory proceeding that we tried in 2019 on this matter. The first page on the top is a before image. And so this is what existed on the property before Mr. Wild engaged in what he calls a conversion to a tree farm and what I call a extraordinary violation of the Wetlands Act. The property was a cranberry farm. Adjacent to it on the right was Pete Hanlon's cranberry bogs. Pete has since sold the property. And back in 2008, Mr. Wild came before the commission and he sought permission for a conversion to a tree farm. And he proposed a particular plan at the time, and he got approval for that plan, and then he just went out and did whatever he wanted. And the result was what is shown on the next page. This is the after image following Mr. Wild's work. He filled some 14.7 acres of wetland, bordering vegetated wetland. And I want to specifically direct your attention to the upland area at the top of the screen of the image, adjacent to North Shore Boulevard extension. That was, and you can see it readily in the prior image, 2 active cranberry bogs that served as flood storage for North Shore Boulevard extension. And I proved to the land court, and I'm going to get to it in a moment, that Mr. Wild's activities interfered with the movement of flood storage waters from North Shore Boulevard over onto his property. And that interference happened in one of 2 ways. It happened because he built a fence and a berm and basically put a dam across the area, and because he filled in that cranberry bog and removed all of the flood storage that was present before he did that. And he has never, despite multiple orders of this commission, he has never restored that bog and restored that wetland. That's 2 acres of wetlands on this property, immediately adjacent to my client's land, that Mr. Wild filled in and never restored despite the orders of this commission. Now, coming forward just a little bit, in 2018, this commission took a whole series of actions in response to that conduct by Mr. Wild. On August 1st of 2018, the commission denied 2 requests from Mr. Wild for certificates of compliance because he hadn't complied with the orders of conditions. And in addition to that, the commission issued 2 enforcement orders, and I'm going to give the board the particulars of those here in just a moment. On August 1st of 2018, strike that, that's the wrong date. On August 2nd of 2018, the commission issued an enforcement order to Peter Wild to stop his work and restore the site. On July 18th, they issued another enforcement order to Mr. Wild for storing piles of compost and animal waste in the wetland buffer and resource areas. All of that took place on that wetland upland area immediately adjacent to my client's property that I described. cutting of vegetation in town jurisdictional resource areas at the end of North Shore Boulevard extension, enlargement of ponds, including a number of ponds that I'll get to in a moment, pollution of pond water through sediment runoff, and operating without an approved farm plan. Mr. Wild, in response to those orders, did a couple of things. He filed a lawsuit against the Conservation Commission in the Barnstable Superior Court, and that case was entered in September 21 of 2018. The commission, in response, filed an answer and a counterclaim demanding that Mr. Wild be ordered to restore the bogs to comply with the enforcement orders and to pay administrative penalties. That case has been stayed since 2018 because of the pendency of a DEP adjudicatory proceeding that I'm going to get to in just a second. But I have for the commission and for your records the complaint filed by Mr. Wild appealing those enforcement orders, the commission's answer and counterclaim seeking enforcement, and the most recent joint status conference filed with the Superior Court in October of this year. That case remains stayed until January of next year. Who wants the pleadings, Mr. Chairman? You want them, or you want me to send them over there? Okay. So, in addition, in response to those enforcement orders, Mr. Wild came forward with a request for determination. And he sought a determination from the Conservation Commission that all of his conduct out there was exempt by virtue of normal maintenance and improvement of land and agricultural use. The Commission disagreed and issued a positive determination. Mass DEP, in the person of Gary McCutch, came out and issued a superseding negative determination from which my clients took an appeal. We tried the matter before a presiding officer back in December of 2019, and in February, Valentine's Day of this year, the presiding officer issued a recommended final decision. Now, the DEP commissioner hasn't yet adopted this as the final decision of Mass DEP, but the presiding officer reversed DEP and determined that none of Mr. Wild's conduct was normal maintenance and improvement of land and agricultural use. The reason for that decision is that the presiding officer...
Excuse me, are you going to be able to wrap it up relatively soon within, we've exceeded the allotted time.
That's right.
Pardon me?
We've exceeded the allotted time.
Could I have some more time? This notice of intent is an attempt by Mr. Wild to wipe the slate clean of all of your enforcement orders, of the judgment of the land court, of the decision of Mass DEP's adjudicatory office, and we object to it. So I'll just put this.
Yes, you can stop at any time. You can stop it at any time.
Okay.
I'll put this in the record, Mr. Chairman, rather than going through it in detail, but this is the presiding officer's decision reversing the Southeast Regional Office's decision and holding that none of this stuff is normal maintenance and improvement. The impact of that means that if the commissioner finally approves that, Mr. Wild has to either win his lawsuits against you in the Superior Court, or he needs to comply with your enforcement orders. And lastly, I'll put in the record the decision and judgment of the land court in the case that I litigated over a week's time during COVID. We did this one on Zoom, if you can imagine that. And importantly, we proved to the land court judge a number of things. We proved that the farm pond that they're trying to relocate this easement around was enlarged by Mr. Wild, no permits, said it was land and agricultural use, and he put that pond in the middle of North Shore Boulevard extension. The judge ordered him to remove the obstruction. In addition to that, we proved to the land court judge that the fence and berm and wood chips and all the rest of it that you've heard about in this notice of intent interfere with flood storage and cause flooding on North Shore Boulevard extension. And I'll put that one in the record as well. Which gets us to the notice of intent. I think before the commission does anything here, it needs to carefully review the history with town council of all of these various proceedings. I think it's wildly inappropriate that this comes before the commission knowing that there's lawsuits in two different courts, that council, and I'm not criticizing Stantec, they're working for a client, but that there was no consultation with either town council or myself regarding the contents of this notice of intent. There wasn't any. At least in we were told he was filing a notice of intent, but we got no discussion of it. My clients do not agree that the removal of all of those trees are necessary. Those, and by the way, there is disagreement as to whether those are quote-unquote nursery stock or pre-existing trees. We do believe that the fence needed to be removed. It needed to be removed forthwith, according to the judgment of the court. And I had a conversation with Mr. Wrigley about this many months ago. And Mr. Wrigley indicated that in his judgment, there was no notice of intent necessary to remove that fence. But nevertheless, they've sought to turn this whole thing into a notice of intent, which is, as I suggested before, an attempt by Mr. Wild to wipe the slate clean of all of the unlawful conduct before, to deprive my clients and the commission of the benefit of the judgments that it has obtained. The commission participated in the DEP appeal. And the commission brought suit against Mr. Wild. And I think at a minimum, the commission should get a lot more information, should get guidance from town council. I'd like to see a site visit with council and with the commission to talk about these so-called nursery trees that are proposed to be removed out here. And under no circumstances are my clients going to agree to a relocated easement for pedestrian access only after they spent 5 days in a trial in the land court and won their right to go over the easement for all purposes for which ways can be used in the town of Sandwich. I'm happy to answer questions. I know I've already taxed your patience, so I don't want to take up too much more of your time, but we object.
Thank you.
Thank you.
May I briefly respond?
Chair.
I'm sorry.
May I just briefly respond to that?
Actually, let's have, is there anyone else for public comment?
Yes, I'd like to say something.
Could you come up to the mic, please?
Hi, Kathy Carl.
Up to the mic, please.
Yes.
Thank you.
Can you please state name and address too, please?
One more time in the mic.
Kathy Walter Carl, 68 and 82 Bruce Road. Attorney Henchy represents my husband and I as well. He referenced the adjudicatory trial we had in DEP in 2019. And I just want to say one thing. I want to just read this, but I also want to hand this in. So I'll give it to you. It is a copy of the affidavit that was submitted into the, to the presiding officer, and it was the affidavit of Peter Hanlon, Jr. And I just want to emphasize, the crap that goes on out there is upsetting, and we've been dealing with it for almost 17 years now. Mr. Wild does whatever he wants. So, having said that, I'm really tired. I've been up 2 days, basically. This affidavit shows Peter Hanlon worked for an internship with Mr. Wild for quite a long time, and then he quit because of everything that was going on. But I wanted to emphasize a couple paragraphs. Attorney Henchy is the one that did this with Peter. I just want to read these 2 paragraphs. Number 12. In particular, beginning in the winter, this is Peter Hanlon, beginning in the winter of 2017-2018, Mr. Wild instructed me and a coworker to place fill along North Shore Boulevard extension for the purpose of raising the grade of his land in that area. Mr. Wild had experienced flooding, and he told me that he wanted to raise the grade in that area to keep the floodwater from getting onto his land. 13. Mr. Wild also specifically told a coworker and me in the fall of 2017 and into 2018 to place fill in the area adjacent to Mr. Carl's land, that's my land, to make it look like nothing happened, quote unquote. We deposited approximately 80 yards of fill. 80 yards of fill is probably 8 dump trucks, okay, of fill, huge dump trucks of fill in that area in order to raise the grade adjacent to the Carl's land. My coworker literally sprinkled pine needles over the top of the fill at Mr. Wild's instruction in order to disguise what we had done. Okay? So that's what we're dealing with out there. That's just a little bit of what's been going on out there. So that's it. That's all I'm going to say.
Thank you.
Thank you. Thank you. Any other public comments? State your name and address.
Good evening. Michael Carl, 82 Roos Road. I'm an adjacent abutter, direct abutter. My issues with the fence, first of all, Mr. Henchy represents over a dozen abutters, so I think he should be given whatever time he needs for 12 people worth of speaking. But fencing, I'm not sure how they measure fences and what fences do with wildlife. I see these fences that he has, which I call unpermitted fences, he calls them temporary fences. They always stop deer and other wildlife from going through, so I don't know what kind of wildlife he uses that these fences don't stop. There's a fence near my property. He was told by one of the court orders to remove the fence. He removed one snow fence, and then he installed a 6-foot-tall chain link fence in the easement he was told not to. I'm happy that he's going to be taking it out. I just want to make sure he doesn't reinstall any fences near my property. It looks like it might be just the other side of the proposed easement if it ever does go through. But he doesn't get any permits for any fences, and none of his fencing is permitted by anyone in the town, the historic or anything like that. And if you could ask the applicant how he measures a fence, is a 6-foot fence that's 1 foot off the ground still 6 foot, or does that turn into 7 foot, or with the swells 8 foot? I mean, this is getting huge, and it's ridiculous. But thank you for your time.
Thank you very much.
Thank you. Any other public comments? Okay. I'd like to close public comments, open it up to the board.
Well, this is a fun one.
This one is a mess. It's just literally a mess, and everybody has a lot of scars from a lot of things that have happened over the years. I think that some things that we have to focus on is the application that is in front of us for this particular piece, right? And one of my questions was if the applicant is asking to come to us for approval because of this land court order, we would need to see the land court order. Do we have the land court order that has that land court order been submitted in its entirety to us?
I did.
You did, but but it didn't come as part of this original package, correct?
I don't think it's in the
Okay. Yeah. So I think that's important for us, because if the premise is that you're here, if your purpose is that you're here to conform to that order, we're kind of blind if we don't know what is in that order. So having that order as part of the application is important for us to understand what it is that is being requested, because right now we have a digested version perhaps of what is being requested in the order. We want to make sure that the order is complying to what is being put in front of us. So until we kind of know that, I don't know what we don't know what we're dealing with in terms of what has been asked to be removed, what kind of surfaces are being requested. Is there supposed to be a road restored in this? I don't know. There's so many questions there.
Yes.
Respectfully, compliance with the land court order is the land court's issue. It's not this commission's jurisdiction. This commission's jurisdiction is over wetlands impacts and the work that's being proposed in the wetlands resource area.
But with respect to your application, the premise of your application was that you're submitting it to comply with the land court order, correct?
That's correct, yes.
Okay,
but
sure.
our
Then
compliance-
why wouldn't that be pertinent to this discussion?
Because you don't decide whether or not we're complying with the land court order. That's the land court to decide. You decide whether or not there's an impact, the activities and the work being proposed comply with the performance standards of the wetlands protection.
There's no way for us to make any determination on this without the land court order.
My point is that you don't need to know, we're happy to submit the land court order, you can read it, but it shouldn't be determinative on whether the work being proposed meets the Wetlands Protection Act standard.
I would say that, if we were looking at this project if there were no land court order, we would be like, why are we removing trees?
That's right.
Why are we doing this?
Why is there a new path being made?
There has been no permitting of any of this fence. Why are we allowing removal of this fence? So
What's happening exactly?
I think that order might actually help your case.
No, it doesn't, because they're not complying with the order at all.
That will be for us to read. We haven't read that, right? So that's why, I think that, it might behoove you to give us some more information so that we can make some kind of mindful decisions. Otherwise, if you don't want to go that route, then we can basically create some kind of a judgment based on the information that we have in front of us right now.
Completely would, yeah, there's not enough information for me to make a decision.
Right.
And you mentioned something about EPA conservation restriction. There's issues about drainage. There's a, to relocate the trees. There's way too many variables here to even remotely consider approving it, much less. I mean, we can continue it, but I agree with you.
I think that one thing that we all need to do clearly in this room is figure out how we're going to work together to get out of this big mess. There's clearly lots of different opinions and sides and views. And if you want to sit there and not be a part of that, I would advise you to become part of that, to work with us, to figure out how we're all going to get out of this situation and not just stand there and say it's like not part of our jurisdiction.
Issues of compliance with the land court order are issues that are within the land court's decision and purview to review. I can see how you would want to see what the land court required us to do and how that translates onto this plan, but this plan is a standalone proposal, and all the other, history that Mr. Henshey went through, it's either already been adjudicated or it's in pending litigation. And you can check in with town council to get the status of that litigation about what's going on, but those 2018 enforcement orders, they're under appeal, and that appeal is pending. And Mr. Wild appealed them, as was his right. The DEP superseding order of conditions, the OADR proceeding, the decision is still pending, and Mr. Wild, he had his rights to defend himself, and he took those rights and he exercised them. I did review this NOI with town council. I spoke to Mr. Whiteside of KP Law and kind of ran him through the same legal history that I did at the beginning. And the insinuation that the easement is pedestrian only is just false. We're not improving, Mr. Wild's not improving anything in this area. That's not what he's required to do. The only thing that the land court judgment requires him to do is clear the right of way of obstructions. And that's what's happening here. So there's no road that's being proposed to build. There's no pedestrian walkway that's being proposed to build. Obviously, the people who have the benefit of the easement, they have the right to do and make improvements on the easement if they want, but that's not what the scope of this project is. The scope of this project is to just clear the right of way of obstructions that Mr. Wild placed so that he can comply with the land court judgment that requires him to leave the right of way unobstructed.
His request is to remove things so that he can comply with something that we're not allowed to see, I suppose. Is how we're supposed to see it.
Continue or deny? Should we continue or deny?
I think it would be helpful for council to weigh in, like that seems useful for our purposes. Because I think what we like with any filing from anyone is the history and the story of it. And it seems like this story is complex and messy. And the more of the story that we can know, the more we can understand the history of the land, because that is simply what we want to do, is understand what this land is and how we can protect it. So if we could get council to weigh in, I think that would be helpful for our purposes.
Would that be possible? Did we have any input from staff?
No, not at the moment. I think there's a lot of history here that's,
That's right.
yeah.
Yes, a lot of history. Dave DeConto knows it like the back of his hand. Maybe a little education with him.
Can we do a site visit? Could we schedule a site visit?
Yeah, I think that would be helpful.
Yeah.
You should. The history here is unlawlessness by the applicant.
Okay. Yeah, thank you.
No.
Well,
We're done.
yeah.
And I need
We're
to
done.
say something. You just heard a representation. This has nothing to do with pedestrian access.
Yeah,
The
absolutely.
cover
continue
letter
for
for
the
the
site
notice
visit.
of
We should do a
intent
site
says.
visit. Okay.
That is
To
a
All right.
continuation,
Let's
do
do it.
we
Yeah,
want,
let's go
we
ahead.
want to do with this? You said?
Yeah, that's
Okay.
right.
You just can't, you can't stand here before the commission and say,
We need to stop. We need to stop.
Thank you. We appreciate your comments, both of you, and we will continue looking at this. So I would like to make a motion to continue file number DEP file number SE662033, Peter Wild, care of Santec Consulting Services. Notice of intent to relocate existing stockade fence, removal of trees, and removal of and upland relocation of approximately 94 cubic yards of wood chips, subject to land court ruling on proposed easement relocation at 46 and 64 Roos Road, Sandwich, Mass, located at map 69, parcels 25 and 24.
Meeting, the 20, do we want to do it in 2 weeks?
Following is December 4th.
Right.
Is that enough time for us to get the information?
December 4th would be better.
Yeah, to December 4th.
Is that okay with everybody?
Just need someone to second it.
Is that okay? Is that okay?
December work, 4th.
I won't be around, but I think somebody from my office.
Great, thank you.
Just need someone to second it.
I'll second it.
Second? All
December
right, all in favor?
December 4th.
Aye.
December 4th. All in favor?
What's
December 4th is a Wednesday.
December 4th is the
All
Wednesday,
in
yeah.
favor for December 4th?
That's right.
Aye.
Everyone? Okay.
Aye.
All right. So it will be continued to December 4th.
Thank you.
Thank you.
Thank you, everyone, for your time on that. Appreciate it.
Thank you.
Next up, I'd like to open RDA file number SCC 2024D-07, Paul Valentine, trustee, care of Downcape Engineering, Inc., which has filed a request for determination of applicability to confirmation of resource area boundary at 41 Cove Road, Forestdale, Mass., located at map 7, parcel 221.
Thank you so much.
Good evening. I'll do my best to get you back on track here with your timing. This is a very straightforward matter. Mr. Valentine, who is in the audience, is considering dividing the parcel. We advised him to have that wetland delineation adjudicated by this commission prior to doing that because it's fairly close to the acreage and we didn't want any surprises. The wetland was carefully delineated by Brad Hall. You've got the wetland delineation flags in there, in the file. This is on a great pond, which has a fluctuating water body, but comes up rather sharply. Nice, clear delineation. I checked in with staff. They looked at it and thought it was reasonable. So it should be a straightforward matter. Just locks in that resource area so we can perhaps look at some permitting on the property. Be glad to answer any questions if you have them.
All right, thank you. Any additional comments?
I visited the site, looked at the wetland delineation line. Bordering vegetated wetland is a little strip along the inland bank there. Seemed pretty agreeable. So.
Okay. I'd like to open it up to public comment at this time. And closing public comment, opening up to the board.
Could I just ask a question about this is slightly off topic, but the western property line, it appears like it goes in front of a number of houses on the western side of that pond. I've just never seen any property like that is. So there's none of that is being affected by this delineation? Because if you look, this property has a strip of land in front of the whole western side of the pond. So this is just focusing on this area right here. Right?
I'm not so sure. So in the packet, this is a property here.
Yeah.
There's no abutters between us and the pond on that side.
Yeah.
If you're looking across the street, there's a few properties, but that's completely unrelated. I don't know if you've got it upside down or sideways or.
I think we're just looking at the GIS of the town, and it's, when we click on that particular property, 41, it's showing that that property is associated with land around the pond in its entirety. So there may be some
The
discrepancies.
stamped
in
plan
the-
is accurate. Let's go with
Got
that.
it. Thank you.
Thank you.
GIS is get it surveyed.
Awesome.
Thank you.
Oh, that's funny. That's the funniest thing tonight. Thank you.
Levity never hurt.
That was my only question.
Okay, all right. So,
So I think we're good.
Yeah,
We're,
positive
a positive 2A determination?
Yeah.
Seems appropriate?
Okay.
Good.
All right.
Thank you very much for your time.
So what do we do? Make a motion? I'd like to make a motion to issue a positive 2A determination to RDA file number SCC 2024D-07, Paul Valentine, trustee, care of Down Cape Engineering, for the RDA to confirm the resource boundary at 41 Cove Road, Forestdale, Mass., located at map 7, parcel 221.
I'll second it.
All in favor?
Aye.
Appreciate it very much.
Thank you.
Thank you.
Approved. Next will be continued filings. I'd like to open up DEP file number SE66-2030, Sarah Eliza Seebeck, care of BSC Group LLC, which has filed a notice of intent for the reconstruction of a single-family dwelling, installation of an elevated septic tank, and construction of an external elevated stairway at 2 White Cap Path, Sandwich, Mass., located at map 94, parcel 101-1. Okay. Do we need to read this now?
Evening, everyone. Hannah Raditz, wetland scientist with BSC, and with me tonight.
Good evening, attorney David Hennig from the law firm Galvin & Galvin in Duxbury on behalf of the applicant Sarah Swick.
I'm Kieran Healy. I'm a land surveyor with the BSC Group, also representing you.
So the revised plan in front of you tonight, I'll just go over the scope revisions that have been updated. So first off, the beach grass, which we had originally proposed within the areas of natural heritage priority habitat, have been moved back. Now there is nothing proposed within the limits of natural heritage priority habitat. The area of beach grass proposed is 500 square feet in sort of a horseshoe shape around the dwelling. This is a little over 2-to-1 restoration for mitigation for the two structures that are outside of the footprint of the original dwelling, which is the raised staircase to allow for access, and the septic tight tank, which is also raised. Updated topo was also conducted on the site, so the survey now is accurate, or at least to the conditions. The other week, I understand that there's sand being put on the nearby beaches, so this topo could change in the coming weeks, potentially. The 500-gallon dry well requested was added, and this connects to the roof and to all structures. In addition, we added a native washed stone parking area, which is beneath the dwelling. This is shown to have room for 2 cars, and the third car that is shown outside of the dwelling is to represent where the neighbor's parking area is, to show that we're not going to be impeding that. The rinsing station is also underneath the dwelling within that stone area, just amongst the cars, and it is connected to the dry well as well. The tight tank was moved 1 foot closer to the dwelling. This is increasing the distance to the property line to over 6 feet, where previously it was under. In the revised letter that we submitted to Conservation, we discussed the compliance with the Sandwich regs, as well as the compliance with the Wetlands Protection Act performance standards for coastal dune. I won't go over the performance standard compliance with coastal dune, as we comply with all of them. However, the performance standards under section 11 and 13 of the Sandwich regs, I'll just briefly touch upon. So for these requirements, a structure that is proposed within a coastal dune should be supported by piles of wood or steel or helical screw anchors. This project will comply. The lowest horizontal member of the structure above the ground needs to be at least 24 inches. This will be 5.8 feet. No alterations of sand volume or grade is allowed within the dune. This is what we are going to keep. The existing grade is what will be maintained, no sand removal. If any changes to grade occurred during the work, this will be filled in with sand of the similar grade to what's on the site. Stormwater control has also been proposed for this dwelling. to manage and capture stormwater to prevent erosion. And the restoration of the dune is also proposed, as I mentioned earlier, the 500 square feet of beach grass. This is quite an improvement to the site. The previous aerials show that this site has no beach grass on it, either around the previous dwelling or within the area between the dwelling and the core envelopes, or down on the beach as well. So this will be adding quite a large area of vegetation as a buffer between the dwelling and the beach. That concludes my comments. Anything else to add? Right, then we'll turn it over to the commissioners.
Any comments?
I know there were comments at the previous meeting made by Chuck, who was the staff before me. So those, as long as those comments are addressed. And then the other question I had was if the applicant who's proposing this rebuild has permission from the actual condo association, like the owners of the association. I'm not sure how that.
I can briefly touch upon that
Thank
issue.
you.
Well, first, I would just direct the board's attention to section, chapter 7, section 7.10, which does define this board's jurisdiction, and any issues that were raised by the condo association, I will provide background information on that. However, though, it does not have any relevance to the Wetlands Protection Act or the town wetlands bylaws. And essentially this commission's role is determining that the proposed activities or the subject of the application are not likely to have significant or cumulative effects upon the wetlands values protected by this bylaw. And I'm sure the commission is aware of what those wetland values are, but nothing raised by the condominium association touches upon those values. But the applicant is in possession of a deed amendment that was filed with the Barnstable Registry District of Land Court back on September 17, 1976, that specifically allows for any unit owner to make betterments and improvements to each of their units, including exterior structural alterations or additions, provided the same is done in accordance with the Town of Sandwich bylaws and conservation rules. And of significant importance is this can be done without the need of written permission of the managing board of the association or any other unit owner. Now, I did mean to print a copy of that deed, but unfortunately what was printed was a temporary easement of this property that has no relevance, but I do have a copy of that and I can provide that to the board.
That answers my question. Thank you.
Anything else? Okay. I'd like to open it up to public comment at this time. Please state your name and address.
Sure. Gabrielle Hunter Enzer, attorney for the Sandwich Shores Condominium Trust. I'm at Marcus Enrico, Emmer and Brooks. And so what council just represented is not the take that the condo association has. This tank would be going on common area land. The condominium documents are extremely clear that any improvements on condominium land would need to be approved by the condominium board. The board has specifically said they do not want an elevated septic tank on the common area, which is completely understandable. It's an eyesore. There are environmental issues. Under Chapter 183A, they are entitled to say what goes on the common area and what doesn't go on the common area. Under the condo docs, they're entitled to say what goes on the common area and what doesn't go on the common area. Nothing has been submitted to the board regarding this new revised plan. I got it from the Planning Commission yesterday. We're willing to work with the applicant, but she needs to abide by the condominium rules. She purchased the deed. She purchased her dwelling subject to the rules and regulations of the condominium. She's made no attempt to try to work with the condominium to get their permission. This is something that's going to affect the entire community. I know last time there were concerns from this commission that there was a septic tank being installed above ground on dunes. I haven't seen anything that's been done in those plans that would address that issue. I think the septic tank's been moved a foot or two, which really doesn't resolve the issue of having it on a moving dune. That's an environmental issue. It's an eyesore for the other members of the condominium. Additionally, the constructed driveway is obscuring another unit owner's area and also is going through the common area of the condominium. You can't just buy a condominium and then do whatever you want with the condominium common area. You don't own it. You need to seek the permission of the board. And the board is willing to work with the applicant, but we need some sort of back and forth. We need some sort of information. We need stuff to be submitted to us. You can't just come in and say, hey, I'm going to put a big tank right in the middle of my lawn, or actually of everyone's lawn. So, I mean, that is essentially, we're objecting to the revised plan. We think that this above-ground septic tank is a huge problem. And additionally, you know, obviously there's the issue of the encroachment on the other unit owner's land. Thank you very much.
Thank you.
Anyone else for public comment?
Hi, excuse me, my name is Gary Delaney. I live at 61 Freeman Ave. It would be the piece of property directly behind where this dwelling was going to be constructed. I provided with the...
We have your letter.
You have my letter.
Yes, that's right.
Actually, would you like to read it?
No, I have.
He has it.
I just wanted to make sure what I had is going on the record, and I'll paraphrase it very quickly here. You know, that dune, I took the measurements based upon BSC's staking of the property. That dune is fragile enough as it is. When you start driving 12-inch piles, somewhere between 12 and 15 of them, down in the ground, you're going to disrupt everything that's there. And it's just going to weaken that dune to begin with. The other part of this is, you know, they mentioned that they're going to put a dry well. Now they're going to dig into that dune to take the water, the runoff water, and put it in there. You can see what's happening to the runoff water when you look at the pictures that I have. I'm getting the runoff water. I'm providing erosion control right now to stop the sand from coming in my yard. This is unconscionable that, one, they're going to drive pilings into a fragile dune. Two, they'd be allowed to dig a dry well when they can't put a septic system or a leaching field in. It makes absolutely, from my standpoint, no sense. On top of that, and I mentioned this at your last meeting, I wanted to expand my shed. And I went to the building department and asked them, you know, what was going to be required. And they told me, well, you're going to have to make all the setbacks, which was 10 feet. My shed currently sits in the corner of a lot. Well, I wasn't going to do that. It was going to put it in the middle of my yard and on top of my septic system. So I said, well, I'll apply for a variance, and was told, you can apply, but I'm going to go and tell you that you're not going to get it. Now, how can I not have a variance to build a slightly bigger shed, and this commission or the town may give variance for a septic tank above ground within 10 feet of the property line and stairs for the structure within 10 feet of the house next door? It doesn't make any sense to me. And, you know, although there's been some renourishment out there, that's a temporary dune. It will wash away in a very short period of time. Thank you.
Thank you.
Thank you.
Any other public comments? Come on down.
Good evening. My name is Brian Butters. My family had previously owned 2 Whitecap Path since the 80s. I lived on Feek Ave for 20-something years, so I've seen all the damage. I've seen the beach renourishment project. I've got 30 photos that I just printed of storms from 2013, 2016. There's no way you should allow anything above a structure or a septic, because what's going to happen when those waves come in, it's not going to go through that. It's going to either go to the left or to the right, and it's going to force those strong waves down, so-called downstream. And you saw when they put the Koyas in down at Bay Beach Lane, if you know back years ago, those houses there, that pushed that water from those storms, and it blew through that cottage that was sitting on the entrance to the parking lot. Yeah. But I called Dave DeConto, and I printed photos. I have them with me. I just want to leave them here so you can bring them. And it shows damage like you wouldn't, the beach erosion, everything. And they're printed. I took them myself. I printed them myself and I brought them. But I'd like the town just to have them. I didn't get back to him because it took me several weeks to print them all up. But if you look at those photos, I mean, they put one of them, they put the sand in, it was as high as this door thing, and 2 days later, all that sand was gone. Right back to square one. The seagrass, they planted it there, it doesn't work. Those storms just come in and come in and come in and come in constantly. It may not have happened, this year or in the next couple of years, but that, it destroyed the place. It's nothing sentimental, I mean, but I've seen it all happen. And it's, it's the bullseye right there at that white cap path. There's not even enough room to get vehicles in there. And to put something up on pilings, and you're going to have that water come right through. It's going to come right in there. It's going to either go underneath, the septic is not going to move. So it's going to cause big damage. But I'd just like to drop the box of photos off and leave them before I go. Is that possible? I'll just go out and get them?
Yep, you can give that.
Okay, yeah. Yeah, thank you.
Thank you very much.
Thank you.
Anyone else for public comment? All right, we'll close public comment, open it up to the board.
Mr. Chairman, if I could just respond to a couple items, just two quick items. One is that we would have preferred to put the septic tank underground. The Board of Health requires as well that it wasn't on choice, but it's to be part of Chapter 5 as well. That's the only reason it's going up in the air. We would have much preferred to put it underground. The second thing is we have a little bit about the drywall. There was another option for capturing water, and that is just putting in a stone bed lined with a pipe and capture the drywall. Basically a 2-foot stone trench on the side of the building. It's called a drip trench. That would also have the same volume, so we wouldn't need to go down and start with that and get a plan if that's a concern that the board would have. And then to speak to the last person that spoke here, by having the tank elevated on the pilings and having the building elevated on the pilings, the water's going to go through underneath. There's going to be no discussion of pushing left or right. It's just going to do its own thing underneath with the pilings. So we're not going to push the wall to the left or push the wall to the right. It's just going to do its own thing with the pilings.
Thank you.
Mr. Chairman, if I could just submit one letter from the Town of Sandwich Board of Health dated January 9th, 2018 that explains per 310 CMR 15.00 of the State Environmental Code, Title 5, Sandwich Health Department will only permit a tight tank that has been designed to meet the requirements of the aforementioned code reference in the address. Just want to provide that to the board.
Thank you.
Thank you. Questions?
Can we talk now?
Yeah.
Yes. I think that for me, the elephant in the room is the fact, the basic premise of this application is that there is an existing structure here, that there is no existing structure here. So I have question in my mind that this is even allowable.
It was a structure, it was demolished, because it was taken down by a storm.
Correct, but it's not there right now.
But they have the right to build it.
Right.
Because it was there.
Quick question on that. You're going to build a structure in the exact same location where one was destroyed by storms?
But they elevated it.
Okay. How are you going to get there? I mean, if there's a flood, how are you going to? It was on the ground before, but if they lift it up and there's a complete flood, I don't understand. I don't. Okay.
If I could, a stairway on the side of the building right here.
Oh, stairway. Okay.
So there's a stairway right here just for that purpose.
Okay. All right.
Do you have Title V compliance with your tight tank on a new construction?
Yes.
You do?
Yes.
It's not really considered a construction, it's a capital.
We were in front of the Board of Health just last week, and we did get approval.
You did get approval? Yeah.
For the tight tank.
Yes, that was, it had to be.
It had to be
It
tight
was
tank.
written by you just got a letter from the former director.
Okay.
When the storm took the house out, he wrote the letter that they would know everything would be allowed. And when you go up on pilings with the house, you gotta go up with the septic, so it's all relative, it's not much more.
Okay. Do you?
It's only, that tight tank would only be allowed because it's an existing house. Like, you can't build, like, we can't go and build a new house on a lot and put a tight tank in instead of a septic system. It is literally not allowed per Title V. But because of the premise of the rebuild, that it's an existing structure, this is moving through the systems. And I still have a question about that basic concept that I think maybe we need some counsel on, because there is some precedent here that this is a pure dune. There's nothing there right now. At what piece of history do we go back to and say this is the existing conditions? Do we go all the way back to where the Native Americans owned the land?
2 years, they have 2 years to build on it.
And when was the structure destroyed?
The Talbot Sandwich regulations say that the septic system has to be submitted to the septic plan within 2 years of the demolition, and that date was complied. It was a published date, and that date was met, and that's what we're
When was did the storm take out the building?
The demo happened 2 years ago.
The storm took out the building 2 years ago. What is the date? What is the date that the storm took away the function of the building? March 3rd of what year? 2000. March 3rd of 2018. Okay.
But the property wasn't demolished. But I'm the building department and all that.
You got the history, so I welcome it. Yeah.
They had 2 years from the demolished date, not the storm date. So the demolished date, I believe, was the end of October. It would have been lapsed. Date of the application has been in my office and it's been approved now for 3 weeks. It has been they made the deadline of having the septic application in the office before the 2-year deadline.
So the structure received storm damage in March of 2018, and it was demoed when?
It was October 2020. Yeah.
And in the damage of the structure in 2018, was it habitable after that, or considered?
Was it condemned?
It was condemned. I believe
It was condemned.
Deemed unsafe by the
It was
building
condemned.
inspector.
It was condemned.
It was deemed unsafe by the building inspector and foreclosed on
Okay.
in 2019.
All right. To me, I feel like council would be helpful in if the premise is that this is allowable because of all of these, I mean, to me, we've got a building that was taken out in a storm in 2018. It was condemned. It wasn't officially demoed until 22, which is tripping these deadlines of being allowed. It feels a little bit like a technicality that I'd like to have council maybe weigh in on the buildability of the lot and the premise that this lot is not there's a lot of harm that is being done to the resource by allowing this raised septic, this new structure on a place that doesn't exist. There's no structure now. And I just kind of disagree with the entire premise of the application, that just because you had an existing house in 2018, that you can rebuild that house and put a tight tank, which is not allowed for new construction. And now we have to accept that. I'm looking at it in terms of the benefit of the environment, right? So if it were good for the environment that we could have a tight tank and everybody could have a tight tank on their new construction, Title V would allow that. But it's clearly not great for the environment to have a tight tank. And I think we should get some counsel on that.
Not to mention the condominium association issue there too. There's.
If I could just answer one question about the tight tank, and that is, a tight tank is actually better for the environment because nothing leaches into the ground.
Yeah.
It's just expensive.
Yeah.
So that's why it's not.
There is a nuance to that, I do understand, because you're talking about, like, truthfully, nothing should be leaching into the dune right there. No, there should be no septic tanks. But what you have is a system that relies on someone to pump it out consistently, and human failure is really, what the world thrives on. So, so you have a system that you can't ensure is going to be maintained in optimum health necessarily, and you're putting this thing in the middle of a dune that doesn't have anything there now.
The alarm guidelines for tight tanks, and one of them is that the alarms go off when it goes to 60%. So then there's an extra 40% of storage there to allow for the time to come in for a pumper to pump the tank.
Sure.
So there is that safety net in there. So it's not like it fills up and overflows and then it gets taken care of.
Yeah.
There are alarms at 60%.
Yeah.
And the thing is, with this, the town of Sandwich has a very specific bylaw that says you need to apply for a septic system within 2 years of the demo of the building, and you comply with that regulation.
Yeah. There is no building here, though. That's my basic thought.
And I think if we're trying to look at projects and the purpose of our committee is to say, is there an improvement on the site? Is a tight tank an improvement on the site? Whatever approval it's gotten.
Right.
And is it an improvement of the site which we know is going to erode in a manner that is
that can
rapid?
condemn a home.
Yeah, and that is looking ahead, the project's ability, despite the grass that's being planted, we all know the land that is Town Neck and the erosion that it is facing and has faced. And if that is our purpose, is to ensure that parcels are improving, the presence of grass, I think, doesn't, for me, overweigh the presence of a large structure that is being placed in a dune, and we're digging up the ground there. So.
One of the reasons for the pilings is that you don't need to dig up the ground. You try to do the pilings.
Yeah.
So you're not digging it up. And the building will be elevated 8 feet up in the air to allow for that any type of erosion, but the pilings will go down 20 plus feet in the ground and be pushed into. So it will withstand those storms.
I think we can appreciate the pilings, lifting it up, taking the well, there's no existing concrete, but lifting it up. If you're going to put a structure there, yeah, it would absolutely have to be on pilings. I think what we have to determine is that there's no adverse effect to the environment, to the resource area, and so that's what we're determining.
And the fact that are we beholden to the fact that there once 2 years ago was a structure that here 4 years ago, 2 years ago condemned. They met a deadline. That's a Board of Health deadline, not necessarily a town or conservation construct.
And I think the other issue too is that we have the condo association, so hearing from council on that, like this common land, I'll be honest, this used to be common land for all of Sandwich. The Town Neck was all of Sandwich's land, and it was decided that it would be divided up into parcels, but if we're talking about common land, this was everyone's. And I think we as a commission are in charge then of everyone's land, and looking back at the original land that was there, really important land for the town. It's not just any parcel, it's really truly like a part of our history and why we are sitting very close to that land. Hence, we really, I think council's input on this would be really helpful.
Okay. So I think we want to do continuation.
Yeah, we're loading them up, so we might want to give them some time.
I know.
December 4th? Right, is December 4th? They want to go to the next one? We could do.
I think we'll just, because we're relying on the fact of someone's schedule that we don't know, we can set a date, but it might have to be rescheduled if we can't get feedback from them by that timeline. So we can set it for the December date, early 4th.
Yep.
December 4th.
Yeah.
Subject to
council advice.
Availability. Yeah. Okay. Wouldn't mind looking at this one either. Maybe.
Yeah, I'll motion to continue DEP file number SE66-2030, Sarah Elisa Siwak, care of BSC Group LLC. Notice of intent for reconstruction of a single-family dwelling, installation of an elevated septic tight tank, and construction of an elevated stairway at 2 Whitecap Path, Sandwich, Mass., located at map 94, parcel 101-1, continued to the December 4th meeting, contingent on town council.
I'll second that.
All in favor?
Aye.
All All right.
Thank you.
Continue to December 4th. Thank you.
Thank you.
And on to certificates of compliance.
Okay. We have a continuance that we just got.
It was like the applicant requested continuance late this afternoon.
Oh, okay.
Yeah, right at 4 o'clock.
All right. This is the 1432?
148.
Yeah, 143,
148.
148.
Route 6A. Hey, if I could read. Sorry, I'm just looking for it here.
So we just need a motion?
Yeah, it's one.
Right here.
Yep, yeah.
All right. So I'd like to open up DP file number SE66-2023, Mary Ann Sullivan, care of Marsh Matters Environmental, which filed a notice of intent for construction of a garage with a second-story apartment and replacement of a septic tank on 148 Route 6A, Sandwich, Mass., located at map 73, parcel 76-0. I'd like to read this letter. Hi, Michelle, Jenna, and Alex. On behalf of the applicant, Mary Ann Sullivan, MME, requests a hearing continuance to the next available. The revised project site plan was not ready for submittal by deadline last week, the 30th, in order for the Commission to review and discuss it at this evening's meeting. Plan changes will include, in accordance with Commission requests, a further reduction in impervious surface to improve stormwater drainage and addition of native plantings, approximately 18 to 20 shrubs. Along the grass margin of the existing parking lot is a measure to replace biomass removed from tree limb removals. Working out the final details and illustration of these final changes just requires some additional time to complete. Please confirm receipt of this email when you have a moment. Okay.
Who wrote it?
So we'll move to continue to the 30th, correct? Am I doing my math here? 20th, the 20th.
November 20th.
Okay.
Yep.
Somebody want to make a motion?
Oh, I need a second.
Second.
All right. All in favor?
Aye.
Aye.
Great. All right, now we'll move on to certificates of compliance. So I'd like to open up the original filing, DEP file number SE661432, Thomas O'Connor, care of Spathia Inc., which filed a notice of intent to demolish and reconstruct a single-family dwelling at Assessor's Map 74, Parcel 54, 11 Georges Rock Road, Sandwich, Mass.
And this work was never completed. It was done on that we have in the docket right now.
So no.
So there's no work done.
So deny.
Okay.
Let me do it. So I'll make a motion to deny. No?
Just close.
It's a COC for filing. They never completed the work. They never
Oh.
did.
Just close
They
out the
proposed
permit.
yeah.
I see.
Yep.
Okay.
So we just close it.
You approve the, we recommend that you approve a certificate of compliance.
Okay.
So you, just to get it, just so I understand, you are approving a certificate of compliance for something that was never done?
Correct.
Correct.
They actually did it, it expired before they actually started the bill. And they've got another notice of intent that they're actually trying to close out, but they're not in compliance right now. Do you remember that?
Yeah.
That's right, 11 George Road, yeah.
But this particular one expired before they actually did the work, so they had to file for another one. So this is sitting on their deed, waiting to be released. So it's no work performed.
No work performed, so that's how it gets noted. Okay, great. I just wanted to make sure that it was noted that.
So we're going to we'll issue the motion, or issue the certificate.
Okay, so I'll make a motion to issue the certificate of compliance with under no work performed for DEP file number SE661432, Thomas O'Connor, care of Sebacia, for the notice of intent to demolish and reconstruct a single-family dwelling at Assessor's Map 74, Parcel 54, 11 Georges Rock Road in Sandwich.
Second.
All in favor?
Aye.
Okay. Next up, original filing DEP. I'd like to open up original filing DEP file number SE661885, Joseph A. and Sylvia A. Maggio, care of Sabathia Inc., which filed a notice of intent for construction of a pool with patio fence and landscaping at map 57, parcel 8, located at 90 Cranberry Trail, East Sandwich, Mass.
I met Mr. Maggio at his home and did a site visit. Everything seemed to be in compliance with the original order of conditions. So I would recommend a complete COC, if you agree.
Cool. Everybody good with that? All right. I'd like to make a motion to issue a certificate of compliance for original filing, DEP file number SE 661885, Joseph A. and Sylvia A. Maggio, care of Spathia Inc. Filed a notice of intent for construction of a pool, patio, fence, and landscaping at map 57, parcel 8, located at 90 Cranberry Trail, East Sandwich, Mass.
Second.
All in favor?
Aye.
Aye. Okay. Moving on to other business, I'd like to open up DEP file SC 661929, Mark Hebb of Hebb Builders, Inc. Requested an amendment process, step 1, regarding shed construction at 295 Phillips Road, Sandwich, Mass., located at map 95, lot 3.
Yeah, the new staff was asked for you to, that you guys understand what we call the step 1. Are you familiar with what this is? So when somebody comes to the office and says we want to make a change to what you approved, the director in the conservation agent will take it into advisement. If it's something small and they feel that they can do it in-house, they'll do it in-house. If they think it should come before the board, it comes before the board. Step 1 is it coming before the board and say, this is what changes. And then you guys can decide how you want to have that change done. You can ask them to file an amendment. You can make it a field change where the staff would take care of it. And, or you could ask them to file a whole new notice of intent based on the scope of the work.
Okay.
So that's kind of what we look for you guys to do. If it's a small enough project, we'll take care of it in-house, but if it's something that the board, we have new staff, so I think a lot more will probably come before the board until everybody's comfortable with how everybody's working.
Yeah.
That's kind of what that step 1 process is. This isn't an amendment, it's a change to a project that we would like the board to tell us how you would like us to take in the file. It could be an administrative review, it could be an amendment process, it could be a notice of intent, or it could be a simple, a staff sign off, which we call field change. So that's the process. I just wanted to make you aware.
Yeah, I think that's fair. Yeah, that's fair enough. And a lot of things are handled at the staff level that's
right. I just have a quick question. Is this something that would normally fall under administrative approval or field change for staff? Or is this something,
I think there's a lot that goes on in Phillips Road, and I think the director, and, with Jenna being new, the director kind of said, you know what, let's take this in front of the board.
That's right.
So he's kind of advising, and he's very good, he's been
Yes, I know.
there.
Yep, I know.
He's been everything, so
Awesome.
he thought that because there's been a lot of stuff going on, let's get the board to look at it. And then if you look at the plan, you'll see.
Yeah, it's
construction into the property yet, or no?
I have not.
Okay.
I believe Dave has. I can't say for certain. I understand it's a proposed shed within existing work limit with a previously issued order of conditions. But the shed is not on that plan. So
And the shed is, what size is the shed?
it's small. It's 10 by 14.
Yeah, so 140 square feet.
In the dune?
It would have to be on 2 foot pilings. Must be raised 2 feet due to dune regulations. So
It is in a dune.
Phillips Road, yes.
Yes.
It's on a very
At Beach, Berry Beach, that's right. I would request, I would think either amendment. I think it should be an amendment because there's Phillips Road is so delicate. Those dunes are getting just wrecked. And that's what I would be comfortable with, an amendment at minimum.
Sure, I would support that, to come in for an amendment, to get it on the record and to have it on the plans.
Yeah, I don't want to just give it a field change.
Remember that when you choose an amendment, it also notifies the abutters.
Yeah, because it does appear to be very close to that abutter's house.
That's right. And that's why I think it should be at least an amendment, if not a new NOI.
Well, under,
They have an open order right now, though.
That's right.
Yeah.
So amendment, okay,
That
we
sounds
good with
good.
amendment?
to do a second dwelling.
That's right, well, you know. Okay. So.
Want me to make a motion for amendment?
Yeah.
It's not formally, you don't have to, they don't have to make a motion, because it's
Okay.
not a formal, this is just a
So I can tell him
conversation.
to.
So now we're
Okay.
gonna tell Bill to contact them tomorrow and say we'd like, the board would like to file a file.
Okay, so we didn't need to close it out, anything like that, okay.
Great.
And I think we have one last item, correct?
Yep.
For Aaron Copeland?
Thank you for your patience.
Yeah.
Yeah, you made it.
You wanna come up here?
It's almost starting to feel like a Mashpee conservation.
Oh, no, please don't say that. I've been there.
Well, that's where I was the last 3 years.
Oh.
Yeah, so I'm used to the 4-hour meetings.
Thank you, thank you for waiting this out.
Yeah, appreciate it.
That's all right.
Chat and whatever. So, do you want me to just say
Why do you want to,
Do you want to just give us a kind of like a brief background of what you're interested in?
Sure. Let's see, I was on the Mashpee Conservation Commission until July of this year. I joined them in January of, I guess it was 21? I don't know. Anyway, and then I moved, so I had to get off the commission. So that's why I really was after this one, because I really enjoy it. I got interested in conservation because I was a caregiver for my mother-in-law. She was battling pancreatic cancer, and the only way that I could get away from, that environment was to go for a run in the woods. So I became a huge trail runner, and then I just got really involved in just Mashpee, all the open space we had in Mashpee. And then I just joined the commission. I was on the sewer commission for a year also. I work in real estate now. I was a chef for 25 years. I retired from that during COVID because I was actually the director of culinary down at Atria in Falmouth. 2 buildings, 200 residents. COVID happened. I made it about 9 months. And then my son had ADD, so my mother-in-law lived with us. She had COPD, he had ADD, so he couldn't go back to school because of her. And then when he finally got ready to go back to school, she got cancer. So my whole life kind of just blew up and turned upside down. So I got into real estate, and then so that's the other thing. It's like when I go out and put on my realtor hat, I'm always talking about, it's not about environmentalism versus homeowners. It's a conversation. At least that's what I would always say to people. If you want to do something, it's important to go and ask for permission, not forgiveness, kind of thing. But when it was starting to happen in Mashpee, I don't know if you're aware of what's going on in Mashpee, but it's become less of a conversation and more of a no, pretty much, when you're a homeowner. So I think it was the right time for me to leave, just because I think that environmentalism and development can happen at the same time. It's just if you do them correctly. Like I just got my green realty designation because I want to talk about sustainable resources, solar, decarbonizing. All of these things are important, and it's becoming clear that we need to do more of that now on the Cape. So I just want to stay plugged in. And now that I'm in Sandwich, I thought I would give you a ring and see if you had space for me. But
We have all the space.
Yeah.
As you can
You
tell,
sound
we're very
really
good at
magical.
Yeah, well, I saw online that there was like one alternate open, and then somebody.
It's me.
Yeah.
So we're gonna the board, if they choose to, can recommend you as a full member, because we do have a slot.
Yeah.
Thank you so much.
Yeah, wonderful. Thank you for thinking of us. We
And
need
what
to
are your
meet
time
up.
constraints? Are you okay with the meeting times, the first and third Wednesdays?
I mean, Wednesday's not a problem. I mean, we used to get there at 6, and I literally was leaving there at 10:30 every Thursday night. And like, I was going through a divorce, and I have a little kid, so I was like, this is crazy. I need to be home. So I'm so glad that you guys seem to have a normal length meeting. And they don't go on and on because it's very.
We've worked hard at that.
So the meetings are starting the beginning of January, moving to 6 o'clock?
That's right.
Is that going to be a problem? Okay.
All right. Thank you so much for coming in. Appreciate it.
Any questions or
Thank you.
You're new to Sandwich. Then what's your favorite spot do you go to for conservation land or outdoor space in Sandwich?
Well, I started trail running across the street from where I live, the old Sandwich Game Farm.
Oh,
Down
okay.
what's it called? That street.
Talbot's Point?
Thank
or-
you. Yes,
yeah.
Talbot's Point.
Gotcha.
Yes, I just walk over there and run, and try not to fall, but look at the ground and run.
Oh, it's It's the best. That the trail to the right where it goes out to the point, it's a great spot.
But it's true, there's so many ruts.
Oh, yeah.
Like, I took a huge spill, thank God nobody was there.
Oh.
But, you know.
Yeah.
Yeah, it's fun.
Awesome.
Thank you.
Cool.
Thank you very
Well,
much.
thank you.
We'll be in touch.
Thank you.
And this is was an animal with one meeting.
It really was.
Yeah.
And we're gonna start at 6 and 6:30 now.
Yeah, that's right.
For the rest of the meeting.
Thank you.
Thank you.
Thank you.
Any other business?
I just wanted to go over a couple of things. Let you guys know that I did speak with Cam, and he agreed to go to become an associate member, so we'll free up that full membership. And Liz has resigned right now. She's unfortunately taking care of a very sick family member. She just can't do it. So, I kind of explained that, it's not that we don't want you, but we need to seat filled. So she totally understood, and she, I told her, and if you're ready, call us. Yeah. And see if we have a seat. And Linda, did we ever get a hold of Linda? Or did you call this?
No, I called her twice. She didn't call me.
Okay. So what I have to do, and I'll do that, we're gonna do it next week. I didn't really want to bother our town clerk today. He was a little grumpy, a little tired.
Shocking.
So we will talk to him on what the protocol is to have these people properly resign.
Okay.
Okay.
Including Linda, because
Linda, I know she
We'll
can
wait.
talk to, so I've got to talk to her. So, the order in which you guys do this, like you're signing everything now, too, you talk about conditions now.
we have it in the past.
Okay, so how do you know how does the staff know? What I used to do years and years ago when I was on the board was that the staff member, you guys, at the end of the meeting, when everybody left, you could stay, didn't matter, they didn't do it to hold everybody up. But now you would go through and discuss what you want the conditions to be.
Is that right?
So you wrote a couple of notes. You would take a couple of notes, and you should, remember we had to come back to get conditions from you guys recently? It should be discussed, like, the gentleman that you want wash sand and, is that continued?
That one is.
That one's continued. But was there any that were closing, that we took any condition, any
I wrote
special
them. I write them
conditions?
down as they say them.
Yeah, so you just might wanna go over them.
Interesting.
It's something that you should.
No, I like it, I'm just
have
saying,
to do,
in the
because
past, Josh never had us do that.
We
We
kind of do this, we
Yeah.
all talk, and then to sum it all up, the staff person has a notes page that they're gonna write the petitions down, and they're gonna add them into the filing. So it's important for all of that, like, she's gonna write notes, and you should go through your notes with them now to say, okay, you had mentioned this.
Unless it's continued.
Exactly.
Yeah.
Don't do
Okay.
it until it's continued. And
Thank
then you basically, go ahead.
I was just put, so if it's continued, though, wouldn't we
Not
want?
continued.
Yeah, we
It's
can't
a
discuss
closed
those because they're
Right,
continued.
right, but if it's continued, wouldn't we want to make sure that we have, that they get the information of what we wanted from them back on the site plan? Shouldn't we clarify that as well? Wouldn't that
These
be
are
important?
conditions, though. The conditions are usually not reflected
this is
on.
what we're requesting. Okay.
They're in addition to what's on the plan.
And if it's
That's what I'm
if it's
talking about.
continued
Right.
based on comments that everyone has and things that they need to add, I
You already-
write all that down to make sure it's addressed in the next meeting.
But the
Which is what I'm
conditions-
struggling with going from Chuck
Okay,
to
but
me.
when you-
So,
So the conditions go into the permit.
Yeah.
So we have to
Yes.
follow that, right? So if you read a note, if Jenna read a note right now that she had taken on.
for example, 90 Wing Boulevard East, you had mentioned, I think, Bernice, the native fescue and organic fertilizer.
Yep.
So that would be added into the condition.
And then if she wanted to elaborate, and then that might have prompted something that you had thought of that you want in there. So these are the kind of things that you should be doing after the meeting's over. It's not over, we're still
We
talking.
haven't adjourned, yeah.
But it helps the staff person get those conditions to be what you want.
No, it's fantastic.
And
We
when
never had
everybody's
that.
going, oh, I want this, and I want that, and I want this, and then somebody says, oh, we don't really need that, but what do you want at the end? We need to know, so it's clear when we issue that permit, okay? That's really important.
We never had that. We've never done it. Never.
Well, I think really what Josh was doing was he was putting in a lot of our agreed upon standard.
Right, for as discussed, from as discussed, that's right.
And that's what Jen's, I'm not trying to say she's doing it different, I'm just saying that it should be reviewed. Because
I agree.
things get left out, a lot of people are talking, saying things, and it should be reviewed, what the staff person took down, and then you can elaborate on it, and you can take away from it. There could have been a miscommunication, or.
Especially in a big, long meeting.
That's right.
Yeah, where a lot of words are being said.
She's not responsible to go back and take care of all the conditions, because this is your board.
That's right.
She's just executing the permit.
We should clarify, tell her what we got. Did you miss something? I have notes, Bernice has notes, everybody has notes,
And as we talk, as you're doing that, you could think it's, something else that you.
That's right.
Okay? And it's up to the applicant certainly can stay and listen, or not, but it's up to you to do the conditions. So if you come up with something that you really didn't think of when you were talking to the applicant, or it didn't get portrayed to the applicant, it's gotta be in his permit.
Okay.
You know what I'm saying?
And that isn't an issue?
No, because you're setting conditions.
Okay.
We're not going you're not going crazy.
Yeah.
You just, we need to be clear on the conditions.
Yeah.
Okay, I agree with that.
I've had places say in the condition, like, you can't have that wall, where you have that wall in a condition where it trips like all kinds of
come on,
problems.
yeah.
So we're not gonna do that.
No.
But I'm just
No.
saying, the
That's
length
right.
of conditions they're quite broad. They can be quite broad.
Okay. We have standards that are there.
That's right.
Always.
That's right.
But you guys at these meetings, you guys have this
Special.
doing.
Right.
You do special, that's why we always approve everything, approve standard and special conditions.
Right, I got those.
Does that make sense? Yes.
Yeah.
And you might already know this, but I know for RDA applications, if there's any conditions you want to include on those, we can make note of that as well. I know typically those permits don't have any, a standard like order of conditions, but they can, if you wanted something specific in there, that's easy enough to add on.
Thank you. Do you have, I only have the list of special conditions. Do you have a list of our standard conditions?
Well, the standard are the ones that are the WPA.
All right.
The state form.
It's in the actual order conditions, we can send you it on.
Can I get that? Yeah. I just like to have them in front of me.
Yeah, that's right. I have a quick question too. So we've been working on the updated, for a long time. Any status? I know you guys are new, and I don't want to,
I think that we at least need to wait till the new year, just because the whole staff is brand new.
Yeah.
So I just think there's so much going on right now, just regular meetings, and you've got all potential meetings going on right now. I know, believe me, I've been doing this for 17 years, and we were trying to do it then. When I was the secretary.
For
So,
bylaw revisions?
Believe me, I know it's been a long time.
Are you referring to bylaw revisions?
You need the last revised.
Sandwich regulations.
Yes,
I
okay.
have the last revised copy. I know I sent it to Josh. He asked for it like a few
And I'm
months.
sure that I have it, but if I don't, I mean, I just haven't even gotten them involved
That's
in
fine.
that yet.
So January, I'll check back with you. Don't worry about it.
Beginning of the new year, don't even hold me to January or something.
I may follow up. Just ask. But if you need it, I have it.
I know it's very important. It's a very important, and it's a lot of work.
It was a lot of work. We did a lot of work. We had many meetings.
Than anybody else.
Thank you.
So we certainly don't want to let it, but just understand why we kind of.
Totally get it. Totally get it.
But we will get back to it.
Okay.
Anything else?
Were there any other conditions other than that one?
Oh, yeah, we had two close out.
We just had the RDA was determined,
90
and
Wing Boulevard.
90 Wing Boulevard, Mr. Brad Holmes, were the only things that closed other than the COCs. And the only condition for 90 Wing that I heard that was specific was the native fescue mix and organic fertilizer.
Are you feeling that that's it?
I don't
The
remember.
ones that I had for him were nothing crazy.
I think it's fine.
Yeah.
Yeah.
Okay. Great. Okay, you want a motion to?
Nothing else. I'd like to make a motion to adjourn the Sandwich Conservation Commission meeting of November 6, 2024 at 8:33 p.m. All in favor?
Aye.
Second.
All in favor?
Aye.
Who second? I'm sorry.
You all did. But I'll